could go on and on, quoting court decision after court decision. However, the Constitution itself answers our question, can a government legally put restrictions on the rights of the American people at any time for any reason? The answer is found in Article 6 of the United States Constitution. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws, or any state to the contrary, notwithstanding. In the same article, it says just who within our government that is bound by the supreme law. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both to the United States and of the several states, shall be bound by oath or affirmation to support the Constitution. Here's an interesting question. Is ignorance of these laws an excuse for such acts by officials? If we are to follow the letter of the law, as we are sworn to do, this places officials who involve themselves in such unlawful acts in an unfavorable legal situation. For it is a felony and a federal crime to violate or deprive citizens of their constitutionally protected rights. Our system of law dictates that there are only two ways to legally remove a right belonging to the people. These are, one, by lawfully amending the Constitution, or two, by a person knowingly waiving a particular right. Some of the confusion on our present system has arisen because many millions of people have waived their right to travel unrestricted and volunteered into the jurisdiction of the state. Those who have knowingly given up these rights are now legally regulated by state law and must acquire the proper permits and registrations. There are basically two groups of people within this category. The first, citizens who involve themselves in commerce upon the highways of the state. Here's what the courts have said about this. For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of highways as a place for private gain. For the latter purpose, no person has the vested right to use the highways of this state, but it is a privilege which the state may grant or withhold at its discretion. There are many court cases that affirm and point out the difference between the right of the citizen to travel and a government privilege. And there are numerous other court decisions that spell out the jurisdiction issue in these two distinctly different activities. However, in the interest of judicial economy, we'll leave it up to the officers to research that further for themselves. The second group of citizens that is legally under the jurisdiction of the state are those citizens who have voluntarily and knowingly waived their right to travel unregulated and unrestricted by requesting placement under the jurisdiction through the acquisition of a state driver's license, vehicle registration, mandatory insurance, etc. In other words, by contract. We should remember what makes this legal and not a violation of the common law right is that they knowingly volunteer by contract to waive their right. If they were forced, coerced, or unknowingly placed under the state's powers, the courts have said it is a clear violation of their rights. This in itself raises a very interesting question. What percentage of the people in each state have applied for and received licenses, registrations, and obtained insurance, inspected their vehicles, after erroneously being advised that by their government that it was mandatory? Many of our courts, attorneys, and police officials are just becoming informed about this important issue and the difference between privileges and rights. It can be assumed, therefore, that the majority of Americans carrying state licenses and vehicle registrations have no knowledge of the rights they waived in obeying laws such as these that the United States Constitution clearly states are unlawful, i.e. laws of no effect, laws that are not laws at all. An area of serious consideration for every police officer is to understand that the most important law in our land, which he has taken an oath to protect, defend, and enforce, is not state laws and not city or county ordinances, but the law that supersedes all other laws, the United States Constitution. If laws in a particular state or local community conflict with the supreme law of our nation, there is no question that the officer's duty is to uphold the United States Constitution. Every police officer should keep the following U.S. court ruling discussed earlier in mind before issuing citations concerning licenses, registration, and insurance. The claim and exercise of a constitutional right cannot be converted into a crime. That's Miller v. United States. Motor vehicle violations are considered by corporate government as a commercial crime. Violations to those are addressed in an unlawful admiralty court. See Article 3, Section 2 of the United States Constitution, which reserves all admiralty court law to the federal courts, not the state courts. Once this information is discovered, any reasonable man would conclude that to travel to and fro upon the earth within his or her own personal conveyance is a constitutionally guaranteed, inalienable right, unable to be restricted by the states. Accordingly, by and through all of the above, the counts should be dismissed. That's all I have.